In this module, we're going to continue our study of U.S. copyright law by looking specifically at licensing, database protection, moral rights, and parity. One of the primary benefits of copyright ownership is the ability to transfer some or all of those rights to third parties. These transfers can be for all the copyright rights in a work, which is generally referred to as an outright assignment, or it can be for a limited portion of the rights provided by the Copyright Act, which usually takes the form of a copyright license. Copyright is a personal property right, and it's subject to various state laws and regulations that govern the ownership, inheritance, or transfer of personal property. It's probably best to view copyright as a bundle of rights, and we mentioned those in Module 1, the right to reproduce the copyrighted work, to prepare derivative works, the right to distribute copies of the work to the public, perform the work publicly, display the work, and any and all of these rights or subdivision of those rights can be transferred. A transfer of copyright rights is usually either an assignment or a license. An assignment of copyright rights is like the sale of personal property. The original owner sells its rights to a third party and can no longer exercise control over how the third party uses those rights. A license is an agreement where the copyright owner maintains its ownership of the rights involved, but allows a third party to exercise some or all of those rights without fear of a copyright infringement suit. A license will be preferred over an assignment of rights where the copyright holder wishes to maintain some ownership over the rights or wishes to exercise continuing control over how the third party uses the copyright holder's rights. A typical software license agreement is a copyright license agreement. The owner of the copyright in the software wishes to grant the end user the right to utilize the software in a restricted way. In return, the end user may agree to limit its use of the software in a variety of ways and to pay a license fee to the copyright owner. An implied copyright license is a license created by law in the absence of an actual agreement between the parties. Implied licenses arise when the conduct of the parties indicates that some license is to be extended between the copyright owner and the licensee, but the parties themselves didn't really bother to create a license. This differs from an express license in that the parties never actually agree on the specific terms of the license. The purpose of an implied license is to allow the licensee, the party who licenses the work from the copyright owner, some right to use the copyrighted work, but only to the extent that the copyright owner would have allowed had the parties negotiated the agreement. Generally, the custom and practice of the community are used to determine the scope of the implied license. Implied licenses have been used to grant licenses in situations where a copyrighted work was created by one party at the request of another. In one case, a special effects company was hired to create a specific effect for a horror movie. The contract through which the special effects company was hired did not assign the copyright in the effect and did not provide for a license for the effect to be used in the horror movie. The court ruled that the effect could be used in the movie through an implied license, since the effect was created with the intent that it be used and distributed in the movie. A commonly discussed scenario where implied licenses are destined to play a major role is on the World Wide Web. When a web page is viewed in a web browser, the page is downloaded through the internet and placed on the user's screen. It's clear that a copy of the web page is being made by the user. It's also clear that the web page is protected against unauthorized copying by copyright law. But it would not make sense to allow the author of a web page to sue a user who viewed her page, since the author intended that the page be viewed by others when she placed it on the web. Rather, attorneys argue courts should find that the web page author has given end users an implied license to download and view the web page. The extent of this implied license is unclear and may someday be further defined by the courts. Although the copyright owner is free to transfer her copyright rights as she sees fit, The Copyright Act contains a non-revocable right for a copyright owner to terminate any copyright transfer. The purpose for this is to give the creator of the work or creator's heirs a second chance to exploit the work in situations where the value of the work may have been significantly enhanced since the original transfer. Generally, there is a 5-year window of time to accomplish the termination, beginning either at 35 years from the assignment if the transfer was made on or after January 1st of 1978, or 56 years from the date copyright was originally secured if the transfer was made before January 1st of 1978. The ability to terminate a transfer cannot be negotiated away, so the author of a valuable book has the right to reclaim the copyright in the book by terminating the transfer, even if the agreement signed by the author stated that the assignment of her copyright rights was permanent and irrevocable. Exceptions to this ability to terminate a transfer are made for those parties who created derivative works prior to the termination. In addition, works made for hire are not subject to this termination of transfer right. A document that transfers copyright ownership or any other document pertaining to a copyright may be recorded in the Copyright Office. Although recordation is not required to make a valid transfer, recordation of the transfer document does provide certain legal advantages and may be required to validate the transfer as against third parties. Databases are generally protected by copyright law as compilations. Under the Copyright Act, a compilation is defined as a collection and assembling of pre-existing materials or of data that are selected in such a way that the resulting work as a whole constitutes an original work of authorship. The pre-existing materials or data may be protected by copyright or may be unprotectable facts or ideas. An example of a database that is protected as a compilation would be a database of selected quotations from U.S. presidents. The individual quotations themselves may or may not be subject to copyright protection. However, the selection of the quotations involves enough original, creative expression that it is protected by copyright. Therefore, a database of quotations will be protected as a compilation, even though some of the quotations are not protected. A database of facts is also protected as a compilation, assuming the grouping contains enough original expression to merit protection. An example of a protectable grouping of facts would be a database of Internet locations for selected legal articles. Each location consists merely of factual information, namely that a particular article can be found at a particular URL location on the Internet. There is no copyright protection for each location. Therefore, while the individual locations can be copied by others, if an entire database of locations or a substantial portion of the database were copied, the copyright in the compilation would be infringed. The creative original expression that is being protected is the selection of locations for the database. If the locations were divided by topic in the database, the organization of the database would also be protected. In the case of Feist Publications versus Rural Telephone Service Company, the U.S. Supreme Court ruled that a compilation work such as a database must contain a minimum level of creativity in order to be protectable under the Copyright Act. Rural Telephone Service Company was a local telephone company in Kansas that published telephone directories based on data that it obtained from its subscribers. Feist Publications was a publisher of area-wide regional telephone directories, covering a much larger geographic range than Rural's directories. In order to publish its white pages, Feist needed to use the information Rural had in its telephone directories. Feist first tried to license the information in Rural's white pages directly from Rural, but when Rural refused, Feist extracted the listings it needed from Rural's directory without their consent. Although Feist altered many of Rural's listings, many were identical to listings in Rural's white pages. Rural sued Feist for copyright infringement in the compilation that made up its white pages. 2 lower courts ruled in Rural's favor, holding that Feist's extraction of data from Rural's white pages infringed upon Rural's copyright interests. The Supreme Court, however, felt that Rural's white pages are not entitled to copyright protection, since the white pages did not meet the statutory requirement for originality. According to the Supreme Court, a compilation is not copyrightable per se, but is copyrightable only if its facts have been selected, coordinated, or arranged in such a way that the resulting work as a whole constitutes an original work of authorship. According to the Supreme Court, the statute envisions that some ways of selecting, coordinating, and arranging data are not sufficiently original to trigger copyright protection. In applying this originality requirement, the Supreme Court held that Rural's white pages were not selected, coordinated, or arranged in such a way as to create an original work of authorship. Rural's selection of listings, their subscribers' names, towns, and telephone numbers, was obvious and lacked the modicum of creativity necessary to transform mere selection into copyrightable expression. Arranging names alphabetically in a white pages directory is so commonplace that it has come to be expected. This holding overruled numerous lower courts that adopted what they called the sweat of the brow or industrious collection test of copyrightability. Under this test, if a compilation was created as a result of a great deal of effort, such as the collection of thousands of names and addresses, copyright protection would extend to the compilation regardless of the creativity or originality in the selection, coordination, or arrangement of the facts. In fact, under this overruled doctrine, copyright protection extended to each fact contained within the compilation. No extraction of facts from a compilation was allowed. The Supreme Court expressly stated that this sweat of the brow analysis was faulty, and that copyright extended only to the original selection, coordination, and arranging of data, and not to any unprotected facts contained within the compilation. In the world of intellectual property, specifically copyright, moral rights are a special set of rights that are owned by the author or creator of a work by virtue of their role as the author or creator. The idea of copyright can be thought of as divided into 2 parts, economic rights and moral rights. The economic rights let someone sell access to a creative work or otherwise exploit it for profit. The moral rights let someone control how a creative work is used in non-economic ways. There are 2 major moral rights under the U.S. Copyright Act. These are the right of attribution, also called the right of paternity, and the right of integrity. The right of attribution says that no matter who gets to exploit the economic rights in a copyrighted work, for example, no matter who it is licensed to, the author still has a right to be named as the author or creator. That is, the author must be named or have a byline. The right of integrity says that the creator of a work gets to prevent any action that would destroy the integrity of the work. That is, if the author reasonably feels that making certain changes in a creative work would undermine the author's creative intent, or the author's vision, or something similar, then the author can prevent that change from being made, independent of any economic rights that another person may own by virtue of a license or ownership of the copyright. What's the status of moral rights under U.S. law? The United States Copyright Act grants moral rights to creators of visual works in Section 106A. U.S. law doesn't grant moral rights to creators of other types of copyrighted works, such as literary or musical works. U.S. law doesn't hold moral rights in very high regard, and only included moral rights under pressure to conform with certain international treaties. Moral rights are very rarely asserted in the U.S., and even more rarely is such an assertion given any weight by a court. Part of the reason for this is that any decently drafted legal document that grants a copyright license will include a waiver of all moral rights, even for works like books for which U.S. law doesn't protect moral rights. Moral rights come historically from France. In many countries in Europe, it's impossible for an author to give up his or her moral rights by contract. That is, if you have a contract with an author that grants you a copyright license and gives you all sorts of rights to do whatever you want with the author's work, the author still retains the moral rights and others as provided under French law. It doesn't matter what your contract says. The French court will not enforce it if it tries to take away the author's moral rights. Often a contract will have an author waive moral rights instead of licensing or transferring them. That makes a lot more sense, but a court in Europe probably won't enforce that either. The challenge for someone based in the US who's working with someone based in Europe is ensuring that US law controls a contract to license a copyrighted work. And yet international law generally says that many aspects of copyright are controlled by the country in which a copyrighted work was created, no matter where any license is subsequently granted. The short answer? In the US, moral rights don't really matter unless you're a visual artist, such as a sculptor, a painter, or a graphic designer. But don't forget to consider them when working out licensing terms, just in case. Outside the US, moral rights can have a huge impact on how you do business. It has been a long-standing practice to poke fun at our cultural icons, symbols, public figures, and celebrities. A parody exists when one imitates a serious piece of work such as literature, music, or artwork for humorous or satirical effect. Parody as a method of criticism has been a very popular means for authors, entertainers, and advertisers to communicate a particular message or point of view to the public. A parody, because it is a method of criticism, must inevitably make use of another creative work. This inherently creates a conflict between the creator of the work that is being parodied, as no one really likes to be criticized, made fun of, or ridiculed, and the creator of the parody. It's also highly unlikely that a copyright owner will grant permission or a license to use a parodist to use their copyrighted protected work in creating a parody. Since copyright law prohibits the substantial use of a copyrighted work without permission of the copyright owner, and because such permission is highly unlikely when the use is to create a parody, it may be necessary for the parodist to rely on the fair use defense to forestall any liability for copyright infringement. However, the fair use defense, if successful, will only be successful when the newly created work that purports itself to be parody is a valid parody. Another line of defense that may be available is the free speech principles incorporated in the First Amendment. Historically, courts have been sensitive to the interaction between parody as a means of entertainment and as a form of social commentary and criticism and First Amendment values. The public interest in such expression could be construed as outweighing the rights of the copyright owner. Entertainers have successfully invoked free speech principles to present wide-ranging artistic expression. However, when commercial gain appears to be the primary motive, such as in movies, books, songs, plays, and visual art, the parodist's work and its defense under the First Amendment and fair use doctrine has frequently resulted in a number of court decisions that are seemingly irreconcilable. The United States Supreme Court in Campbell v. Acuff Rose Music stated that in no uncertain terms that a parody as a form of criticism or comment could be fair use of a copyrighted work. "Oh Pretty Woman" is a rock ballad written by Roy Orbison and William Dees. Luther Campbell and his music rapper group Two Live Crew wrote a rap song entitled Pretty Woman that had a substantial similarity to the Orbison-Dees song. Two Live Crew attempted to obtain permission for their parody from Acuff Rose, the publisher of Pretty Woman, but were refused. Two Live Crew then proceeded without permission to release their rap song and accorded Orbison and Dees with authorial credit and listed Acuff Rose as the publisher. Acuff Rose then brought a lawsuit, which at the trial court level ruled in favor of Two Live Crew based upon its fair use parody defense. This decision was reversed on appeal when the Sixth Circuit ruled against the fair use parody defense because of the commercial nature of the Two Live Crew rendition and the presumption of market harm that the rap rendition might cause for the Orbison Dees song. The Sixth Circuit decision was then appealed to the Supreme Court. The Supreme Court accepted Two Live Crew's song as a parody because the rap song mimicked the original to achieve its message, and because it reasonably could be perceived as commenting on the original "Oh Pretty Woman" or criticizing it to some degree. The court then had to decide whether a parody such as Pretty Woman could claim protection from copyright infringement liability under the scope of the fair use doctrine. To ascertain whether Pretty Woman was protected by the fair use defense, the court proceeded to evaluate the 4 fair use factors. The court determined that the first factor, the purpose and character of the use, favored Two Live Crew because a parody has an obvious claim to transformative value, and the rap song was certainly transformative in that it provided social benefit by shedding light on an earlier work and in the process created a new one. Therefore, under this factor, even though Pretty Woman certainly had its motivation in commercial gain, the court ruled that a parody, like other comment or criticism, may claim a fair use under Section 107 of the Copyright Act. Justice Souter stated that the threshold question involving a parody fair use defense is whether a parodic character may reasonably be perceived in this joinder of reference and ridicule that marks off the author's choice of parody from other types of comment and criticism that traditionally have had a claim to fair use protection as transformative works. The second factor, the nature of the copyrighted work, the court decided was not of much help in this matter, since parody was, by its very nature, could only be used upon an expressive work. The court's analysis of the fourth factor, the effect of the use upon the potential market for or value of the copyrighted work, stated that the authors or copyright owner of the original work would normally refuse to license or grant permission to a parodist to parody the original work. Based on this finding, the court then excluded parody licenses as a potential market that could be affected by parody use. The court then distinguished that Two Live Crew's Pretty Woman consisted of 2 separate elements: the parody of Oh Pretty Woman and the original rap music itself. In distinguishing these elements, the court decided that the parody could legitimately undercut the market for the original song and any derivative works, but that the rap music threatened to illegitimately replace a derivative work market that belonged to the copyright owner of Oh Pretty Woman. Because there was no evidence on what might be the likely effect of Two Live Crew's parodic rap song on the market for a non-parody rap version of Oh Pretty Woman, the court remanded this issue to the trial court for its decision on the matter. As to the third factor, the amount and substantiality of the portion used in relation to the copyrighted work, the court indicated that a parody presents a unique difficulty when evaluating the amount of copying because the success of a parody depends upon its use of the original work, while its art lies in the tension between a known original and its parodic twin. The court then reverted to the conjure-up test that would deny a finding of fair use under this factor only when the parodist has appropriated a greater amount of the original work than is necessary to recall or conjure up the object of the parody. Traditionally, the third factor weighs against an infringer when the heart of the original work has been copied, but it is the heart of the original that most readily conjures up the song for the parody, and it is the heart at which the parody takes aim. The question for the court then became, how much further could the parodist go in copying the original once the heart of the original was used? The court, as did the trial court, believed that Two Live Crew did not use any more lyrics than were necessary from Oh Pretty Woman, and therefore ruled that the third factor favored Two Live Crew's fair use defense. But since the court had already remanded the case on the fourth factor, it then also decided to remand the question of whether the quantity of copying was excessive or not. The importance of the Acuff-Rose case, even though segments of the case were remanded for further findings, was that the Supreme Court reached the unequivocal conclusion that a parody falls within the scope of the fair use defense.